to get you on the phone. It's like I'm leaving the class. And I'm like, I don't care.
I told you. You know, maybe fine.
It did tell me we're gonna get him away later. I ordered them like I guess 3 weeks, you know. Yeah, 120.
It is on me. Oh, it's on them.
No, I believe you because when I ordered you, it said you want to get your 12 hour class.
You know the online.
Yeah.
Amazon. I ordered it.
Yeah. Yeah. No, I agree with you. I remember that happened last semester was one class where I returned it to have it wrong.
Good afternoon.
And then when I got it, I got the new one. I have an extra one.
Good afternoon.
Good afternoon.
Good afternoon. Let's get started. So, as promised, we'll be spending a little bit of time every day working on some practice NPRE questions. The idea here is, look, the NPRE wants to trick you. Rightly or wrongly, that's what it wants to do. And so, practice is the way to be able to learn how to spot its tricks. So, a couple of things. First of all, for those of you who missed this morning, there's something wrong with the attendance widget on D2L. My fault, not D2L's. I've done something wrong. So, no attendance being taken today. I'm going to figure it out and sort it out, and we'll pick that back up Tuesday. Second, please log into D2L for me, because we're going to work through these together, and the resources that you need I've posted on D2L. If you look at the week 1 content, you will see 2 things that I want to, there's a lot of things in there for you. But there's 2 things that I want to draw to your attention right now for this exercise. The first is this slide deck is available to you on D2L. And the idea is these questions have a lot of text. And so by giving you access to the slide deck, we can have both the question in front of you on your device and the answer choices projected up on the screen, and you can look at them at the same time as we work through this. The second thing that I would like you to do, and I neglected to log into this before the start of class, so you're all going to get to watch me log into it. Is the Socrative link. No, stop it. Stop it, Zoom. And move you so that again, feature login. Okay, so let me launch question. All right, guys. So now, when you click on that Socrative link, there is now, you should pop up with a opportunity to answer a multiple choice question. First one. An attorney served as the director of the Environmental Enforcement Division of the State Attorney General's Office, which brought legal actions against polluters in the state. The Attorney General's Office hired only lawyers with 3 years experience or more. It never hired new law school graduates. In the Environmental Enforcement Division, All the lawyers had many years of experience as litigators in that field. The attorney who served as director oversaw the prioritization of cases and implementation of the attorney general's policy objectives and assigned cases to the lawyers in her division, but did not need to monitor their work, train them in legal ethics, or watch for ethical violations because all the lawyers were competent and experienced. Turned out, however, that one of the lawyers committed some ethical violations, some stuff. When these violations received attention in a local news station expose, the lawyer resigned in disgrace, and the attorney general took the position that the director of the Environmental Enforcement Division is not responsible for the actions of this individual lawyer, whom he described as a bad apple in the division. Is he correct? Here are your answer choices. So, step over to your Socrative screen and make your choice. We'll give you a minute. Okay, so let's see what you guys came up with and where to go. Did I? Okay, thanks. Let me ask a really stupid question. Are you guys able to get into the Socrative room?
Yeah.
Okay. What did I do? I don't know where it went. Okay, well. All right, so let's see. Oh, there you are. Okay. No. Results. Here we go. All right. So, not entirely sure what happened, but that's what happened. So, you guys think that overwhelmingly you think that C is the correct answer. So, let's come back and C is the correct answer. So we have a statement of the correct standard, right? And it applies the standard correctly in that it recognizes that simply saying, well, these guys know what they're doing isn't enough to meet the reasonable efforts to give reasonable assurances standard. Okay? So A and D are sort of the easy ones to eliminate because they suggest that government lawyers are held to a different standard than other lawyers. And we know that with the exception of prosecutors under certain circumstances related to prosecution, that's not the case. B is the one that's tricksy, okay? The MPRE and multiple choice tests in general like to give you what are called distractor answers, which are answers that look right, or even are mostly right, but they're not completely right, and so they're not the best answer. Okay? So B gives you the right standard. It says it's about reasonable efforts to give reasonable assurances, but it concludes that what the director did in this case was reasonable. And that's the part where it falls short. All right? Questions about this? All right. Why does Chrome always? Just, okay, whatever. All right, well, if you guys can get in, then we continue. So we have an associate at a big firm. She's feeling overwhelmed. She goes to her partner mentor. The partner says, look, this is normal. You'll sort it out as you get more experience. Does not offer her any sort of support or help or take anything off her plate. She screws up. And the question is the partner mentor on the hook? Here are your answer choices. Now, I think that you are unable to enter them into Socrative because I am not able to start a new activity for you without going through the rigmarole of logging in again. So close your eyes. If you think that the answer is A, raise your hand. Hands down. If you think that the answer is B, raise your hand. Hands down. If you think that the answer is C, raise your hand. Hands down. If you think that the answer is D, raise your hand. Hands down. Open your eyes. Okay. So B is correct. This is a question about Rule 5.1, about the responsibility of supervisory attorneys to manage your workload. Now, let me emphasize for you guys, this does mean, under the rules, a firm that abuses you is responsible when it breaks you. Does that mean that if your firm works you until you break, that you will be able to get them disciplined? What do you think? I would not bet on it for all the reasons we're going to talk about today. But as a matter of the rules, your supervisor is responsible for making sure that your workload is manageable. Okay? Now, what that does not mean is that there's not a strict liability standard, so that's why A is incorrect. C is incorrect because it misstates what the ethical lapse is. It's not the substantive legal error that the associate makes, it's failing to respond to the associate asking for help. That's the ethical lapse. And D is incorrect because it specifically says if you know that a junior attorney is drowning and you take no action, even though you could have, then any mistake they make is imputed to you. Okay? All right. Questions? Here's a follow-up that is not really related to this. Is the junior attorney subject to discipline under the facts in this question? You're nodding your head.
Yes, because she still failed to adequately represent the client, whether or not it was because of a crippling workload or otherwise.
Anybody else want to agree or disagree? Nobody's willing to state an opinion? Yes.
I want to say usually, yes, I would agree with that. It's her fault. She should have done her, but she did do her best. It's not like she didn't try her best and she expressed that she cannot do all of this to a managing partner. There should have been some sort of help with her. And
So there are two reasons why I agree with Ms. Olive. The first one is exactly what she just said. The rule does not impose, as we just discussed with the partner, does not impose strict liability. It's reasonable effort. And by God, there can be no doubt that what she did was reasonable effort. Okay. The second thing is there's no ethical violation for her at all. Making a legal mistake is not a violation of the ethics rules. Okay. It might be malpractice. In the criminal context, it might be ineffective assistance of counsel. But the ethics rules do not require, as Mr. Becker put it, adequate representation. They don't even require the other word that sometimes folks like to use, which is zealous representation. What they require is competent and diligent representation. I don't think there's any doubt that this associate was diligent. And mistakes happen even to competent attorneys. Right? I've seen an attorney stand up, hang their entire case on a passage from a state Supreme Court opinion, have opposing counsel get up and say, Your Honor, what they said is correct, except it comes from the dissent. It happens. So, and it doesn't mean you weren't competent. So, no, there's no ethical violation for the associate whatsoever. Only for the partner, only because they failed to manage her workload. Questions? Okay. Last option. We have a transactional attorney. They're putting together a deal, and we have an associate and a partner. Associate misrepresents the title status of the asset being transferred. Now, I want to note for you, question does not say anything about the state of mind of the associate. We do not know whether this misrepresentation is intentional or not. But when it is made, partner knows it's a misrepresentation. Partner takes no action at the time because they do not want to humiliate their associate or, show, a divided front. But after the meeting, they say, hey, you got this wrong, you need to correct it. Associate says, yep, will do, never does it. So, can the partner be subject to discipline? And here are your answer choices. Take a minute, look them over. Again, eyes closed. Raise your hand if you think the answer is A. Hands down. Raise your hand if you think the answer is B. Hands down. Raise your hand if you think the answer is C. And hands down. Raise your hand if you think the answer is D. Hands down. Open your eyes. So the answer is B. It is absolutely true that we have an ethical failure from the junior attorney. This is a Rule 4.1 failure to correct a material misrepresentation upon discovery. That misrepresentation gets imputed to the senior attorney under 5.1C2. They knew about it. They had an opportunity to correct it. They did not take any remedial action. They're on the hook too. A is incorrect because the rules do not require you to embarrass your subordinates. Okay? Senior attorney was absolutely right to say, okay, this is something that needs to be dealt with, but I do not have to humiliate you by correcting you in front of opposing counsel. All right? And that's not only allowed by the rules, it's probably also best practices in terms of managing your employees. Okay? C is incorrect because you don't get out from under 5.1C2 just by telling the junior attorney, hey, you screwed up, you need to fix it. If they don't take care of it, you have to take some sort of affirmative action. And finally, D is incorrect because we don't play gotcha in the practice of law in this country. If you have gotten an impression that we do, whether it's from the media or from more senior classmates or attorneys that you worked with, or God forbid, professors at this law school, I am here to tell you, whoever told you that, they're wrong. And I continue to say that, even if it turns out that it was another law professor who told you that. We do not play gotcha in this country, in the practice of law. And so, you do in fact have a duty to call up opposing counsel and say, hey, when we told you this thing, sorry, we made a mistake. That is not true. Okay? Questions? Okay. All right. So, in case you didn't notice, the slide deck that you have does not have the answers. You will get answers after the fact. This slide deck will be updated over the course of the semester with new questions as we go. And every time there will be questions without answers. And then when it gets updated, you'll get answers. So you'll have that available as a study aid, both in terms of preparing for the MPRE and in terms of preparing for your exam in this class. Okay. Questions on all of this? Okay. And we are done with this for now. Oh. Anyway. Okay. So I'm a little more chained to this podium because they've changed how the technology works in this room, and I don't have my notes thrown up on this screen for me anymore. All right, so a brief historical digression into how attorney discipline has evolved, right? Prior to the canons of ethics in 1908, attorney discipline, very idiosyncratic, very sort of personalized, right? You have to convince a particular judge in a particular courthouse that you've done something bad enough for them to ban you from that courthouse. Or rather, you have to convince him, because they're all men at this point in time, to ban you from the courthouse, right? But that doesn't mean that there aren't principles. That doesn't mean that there aren't ethics in play. And with that in mind, let's talk a little bit about this. So what I'm about to throw up on the screen are notes prepared in 1850 for a law lecture to be given by Abraham Lincoln. Now, he did not give said lecture. Did you not turn on? Hello?
Now you got it.
I got it? Okay.
Just got along.
He never gave the lecture, but the notes that he prepared were included in his collected papers after his death. So, in retrospect, probably I should have sent this to you before class and let you look it over, but let's take a minute and read this over for yourselves, and then I want to talk to you guys about the things that you see in this. Yes.
Can you please send the link to this? I'm sorry, I cannot read any of them.
The answer is yes, I can. And thank you for asking, rather than suffering in silence. All right, everybody check your email. Mr. Shrestha? Or Ms. Shrestha?
Yeah.
Mr. Shrestha. Would you be so kind as to advise us on something that Mr. Lincoln prepared for his law lecture that seems relevant to you as an attorney in 2023?
Leave nothing for tomorrow, which can be done today.
Okay, and why does that seem relevant to you?
Because tomorrow is unseen, today is seen.
I'm sorry, say that again a little louder. It's not you, it's me. My misspent youth, I don't hear very well.
Because tomorrow is unseen, today in present, we have to live in present.
I'm not quite sure what you're saying. Are you saying that if we don't act today, that we are not guaranteed the opportunity to act tomorrow?
Yes.
Okay. Anyone else think that that's something that we should keep in mind as we practice law, or do we feel like maybe that's an overblown worry? Yes.
I feel like it's fairly relevant. I mean, we never know what future obstacle or distraction is going to pop up in our near future. And if we have time and think, oh, I'll just get this done tomorrow and either work on something else or just take some time for myself. And there's no guarantee that the next day will be any easier or we can efficiently work on what we're assigned.
I think that's right. What's the danger in this attitude? Yes, Ms. Gleason.
You have to pace yourself as well. You can't get everything done in one day. So even though you have this presence of mind, like I have an urgency that I need to take care of things, the stress of getting everything done in one day might be too much.
Do we think do we feel like Lincoln recognizes that tension? This one's a little trickier. Rebecca, you're shaking your head.
I think the expectations for work and the average amount of work back then was probably a lot greater than it is today. They didn't have sort of the understanding of like mental health, things like that are more commonplace.
Well,
Understanding today.
I don't know that I agree with that. Here's why. Here's why. This is not contained in the document that I just sent to you. Does anyone know how Lincoln filed and maintained his client correspondence? He got a letter from a client that he needed to respond to. He kept it in his hat. And there's a story that's told about him where he actually did not respond to a client letter because it arrived the day before he bought a new hat. And it didn't get transferred from the old hat to the new one. Now, what I will say is that, it goes a long way if when something like losing a client's letter in your hat happens, if your first response goes, oh my gosh, I'm so sorry that this took so long. I lost your letter in my hat. So I guess what I'm saying in regard to Mr. Becker's thought is that I don't know that I agree with the argument that the workload for attorneys in the 1840s and 1850s was significantly heavier than the workload for modern attorneys. I think it might be fair to describe it as different, right? In that our workload involves a great deal more sifting through a great body of material to find the things that are relevant and helpful to our clients. Whereas the workload in the 19th century was much more focused on developing and having at your command a much smaller group of authorities that could be more generally applied. Okay. Because what did they not have that we have? Well, Westlaw specifically, but yes, the internet, right? Okay. We're not going to go too far down this rabbit hole. The point of all of this is that the question of how you can balance the needs to make a living and to continue to be able to operate as a practicing attorney with the demands of protecting clients' interests and protecting the community's interests. These are not new problems for the profession. These are problems that existed long before the codification of our professional responsibility standards, and that will probably continue to exist in various forms throughout your career and throughout the career of your children's children's children's, Lador Vador, from generation to generation, forever, or at least as long as there is law. So, with that sort of vision, right, now I want to talk to you guys a little bit about how the disciplinary process works, how it should work, and what are the things, what are sort of the big do's and don'ts, right? And the first thing that really jumps out at me when I think about the disciplinary process is the incredible amounts of discretion that is invested in bar counsel. Okay, so Mr. Ford, how, not in raw numbers, in percentages, what percent of disciplinary complaints result in formal charges?
I think the book said that not very many complaints are heard, just the more extreme ones.
What do we mean by more extreme?
Like the ones that are more criminal, I guess, like the sexual assault, complaints and all that, fraudulent complaints and stuff like that.
Okay. Mr. Durkin. Am I mispronouncing that?
Nailed it.
Excellent. Mr. Durkin, do you agree with Mr. Ford? Do you think that the bar council tends to focus on the most extreme violations?
I think they look at all of them. Trying to think of how.
I mean, what does the book say, right? I mean, these are questions where, like, the book has expressed its opinion and provided evidence. So, not asking you to sort of generate this out of nowhere. What does the book say? Yes.
I think it says up to 90% of complaints get dismissed.
Right. Okay. Up to 90% of disciplinary complaints are dismissed. And that is a choice, right? That's a choice that the bar makes. Mr. Reeves, according to the book, what types of charges are more likely to be pursued versus, and I actually think the book expresses this the other way. What types of charges are least likely to be pursued?
I want to say it's an exorbitant fee cases.
That's definitely one of the categories that the bar is reluctant to pursue. What else?
Well, I found the one that said there. Might have to look at that.
That's fine, that's fine. So, Ms. Bokamp, can you help him out? Oh, thank you.
So it says, many disciplinary agencies will not bound the charges of incompetence against criminal defense attorneys, legal malpractice, complaints arising out of ongoing litigation, or many allegations in civil case.
Yeah. All of these things are things that arguably violate the rules. Malpractice, probably not. Mostly because the bar of competence is quite frankly so low that even malpractice clears it. So let me put this out to all of you, right? Because this is going to be an opinion question. The bar is expressing its disciplinary priorities through the cases that it chooses to pursue. Those priorities, as they are expressed by the exercise of discretion, do those priorities seem in line with what the bar claims is the purpose of the disciplinary process? Ms. Roto, did you? I saw you moving, but you may not have been raising your hand. So if you.
Okay, well, I think the whole essence of our disciplinary committee is to sanction lawyers and protect the public. But since 90% of the cases are not treated, apparently the purpose of it has been defeated. So the public now will not achieve, will not enjoy the purpose for which that committee was set for.
Right. Okay. If the purpose of the disciplinary process is to protect the public from unscrupulous and unethical attorneys, do we think that 90% of attorneys who trigger complaints are in fact ethical and scrupulous? I mean, we can hope, right? Yes.
And with these, especially like the criminal defense attorneys, if the criminal gets nailed for something and their attorney doesn't get them off, they're probably gonna be mad. I think those are so numerous that accounts for a lot of them. And then fees, I mean, nobody wants to pay an attorney because they're expensive. So I feel like so many of those can be dismissed right away because they're not actually unethical or unreasonable. But that probably adds to why it's such a high number.
I mean, I understand the logic of what you're saying, right? Mr. Durking is making empirical claims about the world that are testable. Okay. How would we go about testing them? How would we go about testing them? Yes.
We could sift through the complaints and see if what he's alleging is actually true, like what the facts alleged are, the complaints.
Yeah, that's a lot of work, right? Is there a faster way to do this? This unfortunately is the nature of research with data, right? Fast, cheap, or reliable. Pick, if you're lucky, one. But yeah, right? If we think that the reason that most claims are dismissed, that most disciplinary charges are dismissed, is because they are unfounded, because either there are specific types of clients that are likely to file charges, or there are specific types of disputes that are likely to lead to charges, then looking at the pattern of charges that are made will give us information about that. However, somebody already did that, right? The ABA commissioned a report on disciplinary practices where they reviewed the gravamen, right, the factual basis of dismissed disciplinary charges. Mr. Owen, what did that commission find according to the book?
They found that most are dismissed because the conduct alleged doesn't violate the rules of professional conduct.
Well, that's what they find that the bar said. But what did the commission find when they actually looked at the facts of the complaints?
That
I promise this is not that complicated.
most of the people disciplined are like sole practitioners.
Mr. Green, can you help them out?
I would love to, but I don't know that I'm finding it either. Is it that they're how we're not really criminal?
Mr. Thompson?
I'm sorry, what was the question again? I think.
What does the commission find when they review the facts alleged in these complaints that have been dismissed? The bar saying they do not state grounds for discipline.
If I've got this right, it looks like because of resource limitations, the agencies actually didn't look at most of the complaints. No.
Ms. Harding, Ms. Gleason, do you have an answer?
It said that the complaints were legitimate and there's no real process for the public to have a practical remedy for it.
Right. Mr. Thompson is correct that an awful lot of the time, the bar says there is no grounds for discipline, when what they really mean is we don't have the resources to pursue this. And as Ms. Gleason points out, the commission finds that thousands thousands of legitimate complaints that probably should result in at least an investigation are being summarily dismissed. But it gets even worse or better if you're in the hot seat, so to speak, which is that even if you do in fact engage in misconduct, and even if what you do is egregious enough to get the attention of the bar council, your punishment may be remarkably light. Right? Let's think about on page 88 and 89, the case of William Robinson. So this is a gentleman who it is substantiated, right? The record is clear. There's at least 11 people in prison because he dropped the ball. What discipline is appropriate in that case? What did the Virginia bar want? Yes, what's going on?
The Virginia Supreme Court wanted to disbar him.
Now, what did the Virginia bar want? No? Yes.
The Virginia bar wanted to disbar him, but the Supreme
Right.
Court.
So you gave me the right answer. You gave me the wrong source. Okay. So yes, the Virginia bar wanted him gone. What did the Virginia Supreme Court do? Yes, Mr. Knapp.
This suspended his license for 90 days.
90 days. 90 days. I gotta be honest with you guys. There were times when I was in practice where I didn't do anything that would require a law license for 90 days. Like, it's nothing. Do we think that's appropriate for somebody who is literally responsible for 11 people being in prison? Now, I should say, that is a different question from whether those 11 people actually belong in prison or not. But it is unquestionable that they did not get a fair adjudication of their guilt or innocence because Robinson dropped the ball. And we send him to the sidelines for 3 months? Does that seem right to you? We are not even going to talk about Max the kitten. That's the one that prompted me to be like, oh God, I got to tell you guys. I got to warn you guys. Because I read that and my heart stopped. So let me ask you guys this. How many of you think or know, right? You may be about to graduate in May and you may have a job lined up. Think that you're going to go to a firm of more than 50 lawyers? Nobody. None of you.
I'm sorry, did you say if we're graduating in May or just any of us?
If any of you, whether you think or know, right? Okay. So the 3 hands that I saw in the back, you guys are exempt from the rules of professional responsibility. How many of you think that you're going to go to work for a government agency? Or no, if you have an offer in hand. Okay, you guys are also exempt from the rules of professional responsibility. The rest of you that think or know that you're going to go to a fairly small firm, well, this class is really important because they're going to come after you. Why do you think that is? Let me ask a question that seems unrelated, but is actually very related. Why do poor people get audited by the IRS more than rich people? Yeah,
Less of a chance you're gonna hire an attorney. But
because rich people fight back. And that's why the bar goes after small firms and not big ones. Because big firms fight back. In fact, big firms engage in regulatory capture. They run their lawyers for bar commissioner seats, and then they get seats on the Committee on Professional Responsibility, and they dismiss any charge against their firm. Or they ask their buddies who are also on the committee, right? They recuse, and then I'm a little bitter about big firms, okay? So, I really think that there's nothing wrong in these places, in big firms and government agencies. I'm going to read you guys something. If you are interested, this is from the Department of Defense Encyclopedia of Ethical Failures. In the off time from her work with the Social Security Administration, a senior attorney opened her own legal practice and represented clients with claims against that very same administration. For her double duty, she was sued by a U.S. attorney and ended up agreeing to a settlement that required her to pay the United States $113,000 for this and other violations. Now, what I will note is that what the Department of Defense does not include in the Encyclopedia of Ethical Failures, because it covers a lot more than just attorneys. It covers all federal bureaucrats who are subject to the Hatch Act, and to similar statutes like 18 U.S.C. 205. It does not address whether this attorney was subject to discipline by her licensing authority. It is only telling you the story of the discipline that the federal government imposed. Okay? But if you're interested in these kinds of things, this is a fascinating document. It tells you all sorts of fun stories about the shenanigans that federal employees get up to and the things that the federal government does to sort of claw them back into the fold. But the point being, why do we let, as a profession, why do we let those with resources act with more impunity than those without?
maybe people with greater resources also have greater resources, theoretically at least, to devote towards ethical safeguarding. And smaller firms generally won't have those kinds of resources.
I don't think that's entirely unreasonable. Okay. So for example, big firms more likely to have an in-house ethics counsel who, if there's something that you're like, I don't know, you can go to them and they will do their own research on the ethics of it. And they'll say, yes, this is allowed. Here are the things, here are the issues that might arise, and here's why they don't create barriers. Or no, it's not allowed. Here's the rule that says it's not allowed. And here's the case where that rule was applied to this sort of thing. And so you better not do this, right? So that is one plausible argument. A lot of attorney discipline, like the one thing, and I'm going to tell you this now, right? The one thing that will always drag you in front of the committee is playing with clients' money. Okay, you screw up your trust account, you are going to be disciplined. And big firms are much more likely to have institutionalized processes that either prevent client property screw ups or detect them very quickly and ensure that they get remediated immediately. Okay. So yeah, maybe there is a reason for lawyers in large institutional settings to be less likely to be disciplined. But why is it that the bar is so much more concerned about the kinds of things that small firms screw up as opposed to the kinds of things that government agencies or big firms screw up?
Because it's like your grandma's lawyer versus, you know, a massive corporation's lawyer or the federal government, and they're more concerned about the legal profession being viewed negatively among like the average citizen than among corporations and governments.
Are they? Do we think that they are? I mean, I guess the first question is, do we think that it's okay for there to be a different standard for your grandma's lawyer versus Koch Industries lawyer? Probably not. No matter what you think about Koch Industries, they are entitled to competent, diligent representation that is not conflicted, et cetera, et cetera, et cetera, all the things that we demand of ethical attorneys. You will note the book talks a little bit about some proposals to create like a different set of rules for attorneys who represent sophisticated clients. You will also note that the book is pretty scathing about that proposal. Probably correctly. Okay. I'm just checking my notes, making sure. Okay. So let's pause here to think about a situation that may actually be very relevant for you guys. How are you going to advise a cannabis business? What advice do you give someone who's like, I want to set up a shop to sell CBD products? Yeah, Mr. Simmons.
I guess discuss both the state and federal law. That the federal law is legal, I guess, and the state law might be legal.
Okay, here is my follow-up for you. Can you prepare business formation documents for that business?
No,
Why not?
I don't know. I know it's no.
All right. Rule 1.2D is the rule that governs helping clients commit crimes. Okay. And Mr. Simmons is correct. The rule says, no, don't do it. Now, there are a few states that have specifically adopted comments on Rule 1.2D that impose particular obligations on attorneys advising clients who want to engage in conduct that is lawful under state law, but is formally prohibited, but perhaps inconsistently enforced under federal law. Okay. more or less it's about marijuana, right? Well, if some of them say they're about marijuana, some of them don't, but they're all about marijuana, okay? Kansas has not adopted such a comment yet. And so, Mr. Simmons is correct. Kansas attorneys cannot help cannabis businesses to form themselves or to set themselves up, as with bank accounts and whatnot, okay? Or credit card receipts, et cetera, et cetera, et cetera. Okay. Questions? All right, I would like to turn your attention to the Dennis Whelan case. This is on page 102 of the book. I will tell you, if you are interested in looking up the New Hampshire Supreme Court opinion on this case, the citation in the book is wrong. For whatever reason, the book has styled this In re Whelan, and New Hampshire styles attorney discipline cases. So as in this case, Whelan's case, very old school, very, very 16th century. So if you want to look this up, it's Whelan's case, it's not In re Whelan. So here is my question to you, Ms. Harding. Does this seem fair to you, Ms. Harding?
The outcome of this?
Yes.
So were they completely disbarred or just insured?
Does it matter? Like, is your issue the level of discipline, or do you think that Mr. Whelan didn't do anything wrong?
The level of discipline is what I see a little bit.
Okay, so what do you think he did wrong?
Well, I think he did a good job of explaining that he couldn't ethically draft the codicil to the will. But I think that it ended up being a mistake since he suggested that her attorney do it, who was his law partner. Because he obviously got some of the client's property as well.
So this is to some extent what's happening in the opinion, okay? Rule 1.8 says you can't draft a document that grants you an interest in the client's property, okay? There are exceptions for contingency fees because that's technically what you're doing when you sign a contingency fee contract. But the general rule of Rule 1.8 is if the client wants to give you property, you can't draft that document. Rule 1.10 says if Ms. Harding, so let's say just for fun that we have Harding and Thompson as a law firm.
That's a good sound.
If Ms. Harding is forbidden from undertaking some representation or undertaking some legal action, Mr. Thompson, as part of her firm, is also forbidden. Her conflict, her inability to take the representation is imputed to him. Okay? But when Mr. Thompson drafts the codicil in this, to sort of put our names on this case, that ethical violation is not imputed back to Ms. Harding. So Mr. Thompson's on the hook for drafting the codicil. Ms. Harding is on the hook. Why? According to the book.
Because she sent her client
Well,
to.
He, right? When we're talking about Wheeling, but yes, since we're putting your name on it, yeah. So,
Because I sent my client to Tom.
right,
And I'm not a disinterested party.
Right.
I'm basically a proxy for,
right, and that does what according to the book?
violates the whole premise of a conflict of interest.
Put it in terms of the rules. I mean, the book
Bars
gives it
lawyers
to you.
drafting legal documents for clients that transfer the client's property to themselves.
I'm sorry, say it again.
It bars lawyers from drafting legal documents for clients that transfer the client's property to themselves.
So let me see if I can make this simpler. Read out what the book says.
Read which part?
At the end of the problem.
Looks like picking up at 5.1C.
Yep.
Rules 5.1C2 and 8.4A, because he had circumvented Rule 1.8C, which bars lawyers from drafting legal documents for clients that transfer the client's property to the.
Right. So the rule that Wheelan violates, or Ms. Harding in our hypothetical, is not the Rule 1.8 that is the substantive rule here. It's Rule 8.4A. You will come to hate Rule 8.4A because that is anything that the bar doesn't like enough can become subject to discipline. That is the conduct unbecoming of an attorney, or whatever the particular phrasing is. But that's the rule where if you aren't sure what rule it violates, that's the one it violates. Okay. I want to hit on a couple of things before we wrap up. The first one is related to substance abuse. Lawyers have rates of substance abuse 2 to 3 times the general population. I'm not going to ask anyone to out themselves. I'm going to tell you my story. When I was in law school, I had a group of friends, and we would unwind by going down to a particular bar in Tuscaloosa. That was in downtown Tuscaloosa. Had a very imaginative name. It was the Downtown Pub. And about midway through first semester of our 2L year, we kind of looked around at each other at the Downtown Pub. We went, how many times have we been here this week? So how many times did you think we had been to the Downtown Pub that week out of 7 days?
6.
You are correct. The only reason it wasn't 7 is because Alabama has a no Sunday sales law, and Tuscaloosa County had not exempted itself. So we went, it's probably not healthy. Also, it's bad for our bank accounts. So we said, okay, we're going to go to the pub on Wednesday nights and Saturday nights. That's it. Other piece of the story, I'm studying for the bar exam, right? Just graduated. And I did not do formal bar prep. I did self-study. Not a path I can really recommend. But, you know, you do you, boo. And I was living in this little mother-in-law apartment over a workshop owned by a friend of the cantor at my synagogue. That his house was next door, and it was, these two buildings were on 33 acres of wilderness at the end of a mile-long dirt road. So you know the joke, if the directions to your house include turn off the pavement, you might be a redneck. Hi. To take the trash out, gotta load up the bag, take it down to the car, drive it all the way back to the paved road. I go and I take a bag of trash out, it's probably end of June, before the bar exam in July. I go, the hell? I hold it up to the light. I open it up and I start pawing through it. It's an entire bag of nothing but empty beer bottles. There was no other trash in my house but empty beer bottles. And so what I want you to understand is that if you're going through something like that, whether it's beer, whether it's whiskey, whether it's like I suspect about the valedictorian of my law school class, it's cocaine. His calves were this big around. Whatever it is, I want you to know that other folks have been there. And that this is something that you can come to us and you will not be judged and you will be helped. Because whatever's happening to you, whatever you are going through, it does not define you. And it does not have to define your future, and it does not have to define your ability to be a part of this profession. And so if you need help, you can come to me, you can come to Dean Lowry. You can come to any faculty member in this building. You can go to the counseling center on the main campus. Even if all we can offer you is an ear and a list of resources, you will get that much. Okay. Last thing. At the end of the reading for today, there's a section on law professor misconduct. And I'm sitting here reading it and I get to the discussion question about, what have you experienced about law professors engaging in misconduct? And all I can think is, God, I would really like to keep this job. But if something happens to you with one of my colleagues, or if you hear about something from someone who's not in this class, from about one of my colleagues, I want you to know that you can come and talk to me about that. And I will be operating from a presumption that you're telling me the truth. Okay. You may not know the whole story. There may be things that aren't part of the story, but when you tell me something, I will believe you. And if you need to have someone with you to go and talk to Dean Jackson, because that's who you would have to talk to, I will go with you. Because I will say this, I would be surprised to hear stories like the ones in the book about the faculty here. But we also know that abusers groom their character witnesses as carefully as they groom their victims. And so if you come to me and you tell me that someone has mistreated you, I will have your back in whatever way I can. Okay. But that's unnecessary because none of that happens here at Washburn, right? All right. Questions about what we covered today? Nothing? Great. We'll see you guys on Tuesday. Take care. Have a great weekend.